This is in the District Court of Butler County, Kansas. Case entitled State of Kansas versus Joshua Merle Felkins. Case number 2022 TR 2503. Brett Sweeney appearing for the state of Kansas. James Watts as defense counsel. Defendant Felkins, all by Zoom. This matter comes before the court at this time for pretrial conference. Mr. Watts, are there any announcements to be made?
Your Honor, speaking with the state as well as my client, it is my understanding my client would plead guilty to count one of the information, flee or elude, a level 9 person felony. At time of sentencing, Your Honor, of a discussion with the state and with my client, we believe he's likely to fall. Well, frankly, we're not quite sure, but we believe he will fall in a presumptive probation category. State would recommend the standard mid-range of the appropriate box. We reserve the right to seek departure should that be necessary. We don't believe that will be necessary.
All right. Mr. Sweeney, do you agree with that announcement?
Yes, Your Honor, all that's accurate.
Mr. Felkins, it's been announced that you now intend to enter a plea of guilty and accept conviction for the crime charged in count 1, fleeing or attempting to elude an officer, a level 9 person felony. Is that indeed your intention?
Yes, Your Honor.
I've got a series of questions I'm going to ask you regarding a felony plea. If there's any question you do not fully understand, I will give you the opportunity to confer privately with Mr. Watts at any point. Just let the court know if you need further advice, okay?
Yes, sir.
State your full legal name for the record.
Joshua Merle Felkins.
How old are you right now?
38.
How are you currently employed?
I work for my family-owned business.
Okay, what is that business?
That's a heat and air.
Okay. What's the highest level of formal education that you've attained?
I've done WTI. I graduated from WTI for computer science and technology.
Okay. Do you believe you're going to have difficulty understanding any of the legal concepts that we're going to be discussing in court here this morning?
No, Your Honor.
Have you received a copy of the original charging document in this case?
Yeah, I did, Your Honor. I believe so. I don't have it in front of me, but I believe so.
Do you understand the nature of the charge of felony, flee, and elude?
Yes, yes, Your Honor. I am where I would, if I could, I like to apologize. I know that this was a mistake.
Okay, well, we'll take that up at sentencing, Mr. Felkins,
right.
Whatever your feelings are. You'll be given that opportunity to make a statement at sentencing. You understand that when you enter a plea of guilty, you are admitting the act of flee and elude, which is charged by the state.
Yes, Your Honor, I do.
You also understand when you enter that plea of guilty, you're giving up any legal defenses that you might have had to that charge.
Yes, Your Honor.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Watts, and that you could present evidence on your own behalf at your trial and subpoena your own witnesses to court?
Yes, Your Honor.
You understand that you would also have a privilege against self-incrimination, which means that if you wanted to get up on the witness stand under oath and tell your side of the story, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that?
Yes, Your Honor.
You understand that when you enter a plea of guilty, you give up these valuable trial rights that the court has described?
Yes, Your Honor.
Felkins, do you understand that you have a right to a trial by jury, and before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, Your Honor.
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt?
Yes, Your Honor.
You understand that you have a right to appeal a guilty verdict if you have a trial?
Yes, Your Honor.
You further understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgment of conviction after you enter such a plea?
Yes, Your Honor.
Felkins, are you aware of the possible penalties that could be imposed as a result of this guilty plea that you're attempting to make?
Yes, Your Honor.
Let's go over those possible penalties. This is a level 9 offense under the Kansas Sentencing Guidelines Act. In the most favorable criminal history category of I, you could receive as little as a 5-month sentence. However, In the most serious criminal history category of A, you could receive up to a 17-month sentence. So the sentencing range is 5 to 17 months in prison, depending on your criminal history. As you participate today, we do not know with absolute certainty what your criminal history is. You better than anyone else participating, I don't know what your own criminal record looks like, but that will be researched by the Court Services Department. And based on the outcome of that research, as of the time of sentencing, that will determine where you fall along the level 9 line, and then you'll be sentenced accordingly. You understand that?
Yes, Your Honor.
Category C through I are presumptive probation. However, if you have 2 or more person felonies, which count on your record at time of sentencing, you would be in a presumptive prison box. Do you understand that?
Yes, Your Honor.
There's 3 numbers in each grid box. Do you understand that it's generally up to the court to determine which of those 3 numbers you would receive as an actual number of months prison sentence?
Yes, Your Honor.
All right. You also understand that you could receive up to a $100,000 fine for this offense?
Yes, Your Honor.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution of victims, if any are owed, as part of your sentencing orders?
Yes, Your Honor.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you would do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, Your Honor.
Mr. Felkins, you understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, Your Honor.
Mr. Felkins, the Kansas Sentencing Guidelines Act is much more than the sentencing grid that I referred to earlier. It's an entire book of sentencing rules and laws. You understand that if any special rules apply to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence.
Yes, Your Honor.
Mr. Felkins, did you have an opportunity to discuss matters like that with your attorney, Mr. Watts, before proceeding here today?
Very, very briefly, but we did talk about it, Your Honor.
Mr. Felkins, do you want any more time privately with your attorney now before we go further?
I think we're okay, Your Honor.
All right. Are you satisfied with the services and advice provided by your attorney, James Watts?
Yes, Your Honor.
Now, this guilty plea that you're attempting to make hasn't been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, Your Honor.
Was there anything that you thought was part of this plea agreement that hasn't been accurately discussed on the record already?
No, Your Honor.
Felkins, you understand that if there are any plea agreements between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. You understand that?
I do understand that, Your Honor.
So let me ask you, how do you formally plead to this charge in count 1, felony flee and elude?
I do plead guilty, Your Honor.
According to the state's charging document, this flee and elude took place on August 2 of 2022. Is that when it happened?
Yes, Your Honor.
Where did it happen at?
Leaving El Dorado Lake.
Okay, in Butler County, Kansas?
Yes, Your Honor.
All right. What did you do that would constitute fleeing or attempting to elude an officer, Mr. Falcons?
I just there. I didn't do anything. I wasn't thinking right.
Okay, but what did you do precisely? I trust the law enforcement officer attempted to pull you over.
I just continued to. I just kept going, Your Honor. I just didn't pull over.
All right. And there was some sort of clear signal that you were supposed to pull over?
Yeah, he had his lights on. Look.
Okay. All right. What kind of officer attempted to make the stop? From what department?
It was a park ranger or park.
Okay. Also, it would be the position of the state in the charging document that you engaged in reckless driving. What did you do besides just keep going?
It says I was speeding, but I wasn't speeding. I just was going the speed limit. I just wasn't stopping.
Okay.
Your Honor, I can supplement.
Please do.
Yes, Your Honor. So I can tell the courts that on the day listed in the charging documents that he was pulled over by an officer with the Kansas Department of Wildlife and Parks. While the officer was standing at the window, Felkins put his vehicle in reverse. Felkins struck the patrol truck and narrowly missed the affiant as he drove off at a high speed. The affiants attempted to call dispatch, called the pursuit over the radio. The officer estimated in his affidavit that Felkins drove over 100 miles an hour on the 2-lane road, passing a truck moving in the same direction. He passed 3 other vehicles moving in the opposite direction. They were able to put up a police roadblock and eventually successfully deflated all 4 of his tires at the intersection of 12th and Main Street, causing the vehicle to pull over at north of the main Casey's parking lot.
Very well. The defendant's statement, as supplemented by the prosecutor, does constitute, in the view of the court, a legitimate factual basis for the offense.
Yeah. I guess I just don't.
So, Mr. Felkins, do you now freely, knowingly, and voluntarily enter a plea of guilty and accept conviction for felony, flee, and elude?
Yes, Your Honor.
All right. Mr. Watts, do you know of any legal reason why the court should not accept your client's plea?
I do not, Your Honor.
Mr. Sweeney, do you know of any such legal reason?
No, Your Honor.
Mr. Felkins, do you know of any legal reason or any other good reason why the court should not accept your plea?
No, Your Honor.
The court will accept the guilty plea made by defendant Felkins and finds that that plea is made voluntarily. He has an understanding of the nature of his charge and the consequences of his plea, and a factual basis for the plea does exist. The court therefore finds the defendant convicted of felony, flee, and elude, a level 9 person felony. Count 2 is dismissed pursuant to plea agreement. The court will order a pre-sentence report be completed to accurately determine Mr. Felkins' criminal history, and the court will set an appropriate date for sentencing. All right, Mr. Felkins, I'm going to set your sentencing date for Monday, January 23 at 1:15. Mr. Felkins, I'm going to direct that you do one of 2 things for your sentencing. You'll need to either appear in the office of your attorney, James Watts, in El Dorado, or you need to appear at the Judicial Center's Zoom location, what we call the Sallyport location on the south side of the building. You can choose either option, but I want to make sure we don't have any technology issues. Things were good today, but I want you either in the office with your attorney so that you have access to him and any advice he needs to give, or be at the Sallyport location at the Judicial Center. Okay?
Okay.
Further, Mr. Felkins, I'm going to need you to contact Butler County Court Services today. I can give you a number to write down, Mr. Felkins, and just let them know what you just pled to. You just pled to a flee and elude, a felony. And then they'll give you further directions as to what you need to do to complete the pre-sentence process. Mr. Felkins, I'm going to leave you out on bond during this time, but you may have 1 or more assessments they're going to ask you to do.
Bill.
I've set this sentencing about 8 weeks out. I'll hold you responsible if those assessments don't get scheduled and completed, because you got plenty of time to do that. So make sure you contact them and just follow their directions regarding scheduling of any assessments, okay?
Yes, Your Honor.
All right. Mr. Sweeney, is there anything else we need to address today regarding the Felkins matter?
No, Your Honor.
Mr. Watts, anything further at this time, sir?
No, Your Honor. Thank you.
Mr. Felkins, you have any questions or concerns about what we've done here today?
No, Your Honor.
Very well. If there's nothing further, then the Felkins matter will currently be in.
To depart on this matter last Thursday. After checking the eFlex system, it appears it has not actually been approved yet, which is kind of surprising after 4 days. So I have just
You don't work weekends, counsel.
Well, I've just sent Your Honor a copy of the email by email a copy of the motion. I'd also previously sent you a copy of a number of items that we had attached to emails from persons who wish to speak to the court. And just so the court is aware, I have a 1, 2, 3, 4, 5, 6 people in the office, including myself, some of whom would like to speak with the court as we proceed.
Are these people who have not submitted letters?
They are people who have submitted letters, but as Your Honor may be aware, those submissions, should the state wish to have them cross-examined, would be hearsay. I know we don't typically do that, but I wanted to make sure that they were in front of the court and it could be heard.
Very well. Let the record reflect that the court did, just before court, receive by email a copy of a motion for dispositional or durational departure. I trust, Mr. Sweeney, you've also received one?
Your Honor, I just received, I think probably in the same email that the court did, the motion for departure, and I'm working through reading that right now, but I'm almost finished.
Do you have the numerous letters that Mr. Watts submitted last week?
Yes, Your Honor, I was provided those and I was able to read all of those.
All right. Let's formally call the case. It is State of Kansas versus Joshua Merle Felkins. It's case number 2022 TR 2503. Brett Sweeney appears for the Butler County Attorney's Office in the state of Kansas. James Watts is defense counsel. Defendant Felkins appearing in the office of his attorney, Mr. Watts. This matter comes before the court at this time for sentencing. Court's docket notes indicate that Mr. Felkins appeared before this court on November the 29th of 2022. At that time, he entered a plea of guilty to count 1, level 9, flee and elude. A pre-sentence report was ordered. He was to comply with assessments, and sentencing was set for today. Court has received a pre-sentence investigation report compiled by Jessica Morgan, pre-sentence investigator. Jessica is present on this meeting. I trust each attorney has received a copy of the pre-sentence report, and I'll ask the state's attorney first. Is there any objection to the criminal history as stated in the report?
No, Your Honor.
Any by the defense, Mr. Watts?
Your Honor, we have reviewed the criminal history. We have no objection.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score B, and the court will proceed further accordingly. Mr. Sweeney, do you know of any legal reason why sentencing should not proceed in this case here this afternoon?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
I'm not, Your Honor.
Mr. Felkins, are you aware of a legal reason or any other good reason why the court should not proceed further with your sentencing today?
I am not, Your Honor.
Court will proceed further then. I do note that there has been a departure motion submitted in the case. Again, entitled motion for dispositional or durational departure. Mr. Watts, you may proceed further on this motion.
Thank you, Your Honor. The first item on this motion, obviously, is that Mr. Felkins is a B on the grid. And many times when people come to the as a B on the grid, they have a substantial history. It makes them that B. In other words, they have earned it over a long period of time. That is not this case. This case is very unique in that respect. All the convictions that make Mr. Felkin a B on the grid are first very old. They're over a decade old, and they're completely unrelated to the instant offense. In fact, as I've been speaking to Mr. Felkins here this afternoon, Mr. Felkins went on a single case over a decade ago from effectively no criminal history at all to a B on the grid, and he did so with a plea in one afternoon. I don't know what the circumstances of that case were. Interestingly enough, when I spoke with Mr. Felkins a few minutes ago, he tells me that on that afternoon, a decade ago, no one told him the repercussions of the plea he was entering in terms of where it placed him on the grid in the future. He's certainly aware of that right now. That history, of course, is a single felony of no drug tax stamp, and then 3-person misdemeanors for endangering a child, 3-person misdemeanors for stalking. And those combined make him, at this point, a B on the grid. They obviously have no connection to the instant offense. And it's important to remember In the decade plus since that time, approximately a decade since that time, the only history Mr. Felkins has is a single no driver's license in possession. So that speaks to Mr. Felkins. These convictions are quite old. They're very unrelated to the instant offense. Mr. Felkins has demonstrated since that time he is hardly a threat to the community, and we believe that supports departure in this case. Secondly, Mr. Felkins is a benefit to his community at this point. He works in a family business. In fact, there is a representative from that business who happens to be his mother as well, who has provided a letter to the court and is here in the office to speak to the court should she wish to speak and should the court wish to hear from her directly. It appears that he was not only a valuable part of that business, but during the recent pandemic was an invaluable part of that business. The business may well have not survived without his willingness to work without pay when it came down to it. Hopefully they've made that up since then, but for a while, it looks like it was kind of touch and go. And Mr. Felkins carried that business through the other side of the pandemic. Third, I think the circumstances of the case do matter. At the time of this incident, Mr. Felkins is struggling with a divorce and the loss of his children. He's trying to cope with that. That does not excuse what happened, far from it, but it does help explain it a little bit. More important, what has he done since that time? He's been attending classes for depression. He's been attending drug and alcohol addiction classes and issues. He's completed those classes. He is, as I understand it, in the process. You was telling me you're doing the Batters Intervention Program. I think it was you or another client. Been doing the Batters Intervention Program since that time to rebuild his relationships and rebuild his life. And one of the letters that we included was a letter from Addiction Recovery and Resources in Wichita, ARROW, I like that acronym, to support that. And finally, Your Honor, Mr. Felkins has taken responsibility for this act. He acknowledged what he did. I think importantly, he didn't hesitate to acknowledge what he did. This case resolved itself by about the third appearance. There was a waiver of preliminary hearing. There was a plea shortly thereafter. He obviously tried to negotiate the best plea he could get, as any person would, but resolved the matter without dispute over what happened, without any arguing or complaining or frankly, waste of the court's time. And that acceptance of responsibility and recognition of his responsibility is something we believe that can support a departure sentence, just as, by the way, refusal to do that, the denial of responsibility, could be considered an aggravated sentence, an aggravated factor, were it to go the other way. For all of those reasons, Your Honor, and frankly, for these 4 other people sitting in the room with me, his family with him, we would ask this court to consider a departure in this matter to probation. I have every confidence he will successfully complete that probation in a matter acceptable to the court.
Very well. Thank you, Mr. Watts. What is the state's position regarding this request, Mr. Sweeney?
Your Honor, the state would argue against departure in this case, and I can go ahead and give the state's formal recommendations and an argument against departure at this time if the court would like.
You may do so.
Thank you, Your Honor. As I previously stated, Your Honor, the state is recommending the presumption in this case, which is presumptive prison as is indicated by the PSI. The state's recommending the 14 months in the Department of Corrections. He would be eligible for 20% maximum good time percentage. He would have a 12-month post-release supervision duration, as well as 1 day of jail time credit. The state's not requesting a fine in the matter. We would be requesting the court costs, of course, and then any attorney's fees if the court finds them to be applicable in this matter. Your Honor, with respect to the departure motion, I'll say this. As far as the priors in his criminal history, I'm not sure of the exact facts of that 2011 case. I would acquiesce that I think that 2011 case is essentially what makes him a B on the grid here today. I'm not sure what the facts of that case are. But it is what it is. There's a reason that those person misdemeanors aggregate, and the legislature, in its wisdom, has seen to make those person felonies, and he stands at a B. Now, moving on to the present offense, Your Honor, I'll just say this about flee and eludes, specifically felony flee and eludes, is that I think they ought to be taken seriously. And the reason is because I think that there's a conscious disregard for others' safety on the roadway when individuals take off from law enforcement in an attempt to evade them, especially when you reach high speeds. You have that disregard for others' safety and potentially put others in jeopardy of being, especially at those high speeds and reckless driving behaviors, being injured pretty seriously. And so for that fact, Your Honor, I think that particular offense ought to be handled pretty severely. As far as the impact on folks' lives, I get that. It's not lost on me that there's an impact on, I'm sure, Mr. Felkin's family's life, and then also, not the least of which, probably an impact on his life if there's an incarceration sentence that's ordered. But I think the punishment fits the crime in this case, and the state's asking for the departure motion to be denied and the presumption to be followed.
Very well. Mr. Watts, were you going to have some persons address the court? Now, I don't necessarily need to hear from anyone who submitted a letter, because I'm sure it would just likely repeat what they've already said. Is there someone other than the ones that have submitted letters to the court?
Well, Judge, that's what I want to make sure of here today. I have a letter from Kayla Madrigal.
Yes.
That's here. She is here. I have a letter from, turn this around so I can read it. This is from Arrow Addiction Recovery and Resources of Wichita. I don't believe that person is here. So that is not in present. And there is a letter as well from, make sure I get all the persons here, from Alana Felkins. That's mom, Alana, and she is here. Would have that letter as well. And I think the fourth letter is
For Robert Felkins.
I don't know that I have the one from Robert Felkins. But Your Honor, these folks are here in the room. If they wish to speak to the court, would ask the court give them an opportunity to do so.
What's the state's position on that?
On the letter from Mr. Robert Felkins?
No, whether you have any objection to these people addressing the court.
Well, Your Honor, I think if we have the letters, that some of the testimony may be duplicative. I think the letters would suffice. I believe that's a discretion of the court, though, in the interest of what the court finds relevant.
Very well. Just a moment, counsel.
The only one he may not have is you two. Did you not? Pardon?
I did.
Okay.
Yeah, you did email because that's why.
Yeah, I sent him.
I got the
Let's see if I
email.
can find the sent items here.
That's why I pulled them off.
Counsel, rejoining the meeting fully, I have an email letter from Brandon Felkins.
Okay.
The others that you mentioned I all have, but not one from a Robert.
I think that may be the only one that we may not have.
And I think that's the one that I don't have as well. I have the others that were previously mentioned.
Okay. Your Honor, if Robert wishes to speak to the court.
Sure. Like, yes. Yes.
Slide over a bit so he can sit right here. Sir, would you identify yourself to the court and tell the court what you wish to say?
Robert Merle Felkins, and I'm the father and the employer at the same time. And I would like to just read my letter that I had originally submitted.
Very well, you may do so.
Honorable Judge, in the case of 22 TR 2503. My name is Robert Felkins, CEO. I am the father of Joshua Felkins, and I also his employer. I'm writing this letter to you on behalf of the defendant, Joshua Felkins, asking for leniency in the judgment of his case. 22 TR 2509. Joshua is a vital part of our lives and in our business. Even before Josh graduated from WTI in 2005, he began working with me. He began as a helper, not knowing much, but was persistent and hung with the steep learning curve and promoted through the years to be my technician's manager. Joshua also takes care of sales and bids for the new equipment installation, performs service calls and installs when needed. He is a small family-owned company, so each family member and employee carries out multiple tasks. However, Joshua has been with the company the longest and knows enough to be able to train new technicians and keep them on task for jobs, along with the running the company and to help make crucial decisions of the company. He is truly a vital cog in a small machine we call a company. I like the two examples of Joshua's importance to me and the business include, example one, we have a 1.4 million project that he bid and will be needed to run and supervise this project. This project is expected to last 9 months to 1 year, beginning in April or May of this year, which at this time will be the largest and most income project All Right HVAC has ever had. To lose Josh in this project would be a crucial loss and a severe blow and possibly a huge financial impact to our company. I'm trying to semi-retire and Josh is vital to take over the business and responsibilities to cover while I'm not here to be in the office and the field to keep it running as it should during my absence. Example two, we have several small projects from 1 day to 2 weeks. Joshua is a vital part of all, and these projects from ordering and picking up parts and equipment to overseeing the technicians and installers in the field. He is a vital part of troubleshooting on the phone with the technicians when they are having issues in the field. I'm so grateful for him and know because of his help, this is why our business is still running today and is crucial to my retirement in the near future. Since Joshua and his wife separated in November of 2021, Joshua has tried to spend as much time with his children and to be the father he needs to be. He rarely misses his youngest son's wrestling matches, which are almost every weekend. He mentors, trains, and encourages his oldest son, who also works for us. Joshua has been to daddy-daughter dances and tries to be there for all their school and sporting events. I know that this separation has taken a hard toll on him emotionally and physically. He did not take it well and made some mistakes in his actions during the initial shock of the end of his 19-year marriage. I encourage him to see a counselor and to get his life in order, and he has worked very hard to do that. Joshua's been working hard to get a new home for himself and his children to stay at, to seek help, to clean up his life, and to correct the wrongs and terrible decision making. Joshua understands what he did, and he regrets breaking the law. He has worked hard to keep himself out of trouble and get back on the right track, and is working hard to get custody of his teenage children, especially his daughters, who I know need a father, to love them and encourage them to make right decisions as they begin their journey in life. I know his younger son looks to Joshua for encouragement and support in his sports, especially wrestling. I truly believe children need a father. I believe an extended term in jail would have a dramatic effect on his family, and I know it will have a huge impact for our business. I implore the court to consider all this and ask for a leniency for Joshua Felkins. Sincerely, Robert Felkins.
Very well. Thank you, Mr. Felkins. Is there anything else to present in support of your departure, Mr. Watts, the court having considered the other letters that you've submitted?
I don't believe so, Your Honor. Thank you.
All right. Very well. Court will note for the record that earlier, Mr. Sweeney, I will ask if there's any victim or members of a victim's family who desires to address the court.
No, Your Honor.
All right. So let me ask you then, Mr. Sweeney, is there anything that you would add to your prior remarks?
No, Your Honor, I think I would stand on my prior statement.
All right. Mr. Watts, any formal recommendations that you care to make at this time?
Your Honor, in terms of specific recommendations, we would, similar with the state, recommend the standard bid range of 14 months of the Department of Corrections with the 20% good time and 12 months post-release. However, consistent with the motion just heard, we would urge the court to grant a departure from that presumptive prison sentence, place him on probation with community corrections. I will not re-argue that. You've heard the reasons for that. Would simply make that recommendation at this time. Should the court decline to grant a dispositional departure, we'd ask the court to consider secondarily a durational departure. As I always argue on the motion such as this.
What are you seeking by means of a durational departure, Mr.
Well,
Watt?
should the court decline to grant a dispositional departure, we'd urge the court for a durational departure to half the sentence that would otherwise be recommended.
Which in this case would be 7 months in prison, correct?
Yes, sir. Yes, sir.
Very well. I understand your position. Anything else, Mr. Watts?
No, sir. Thank you.
This time, the court will address the defendant, Joshua Merle Felkins, personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he personally would like to present to the court. Mr. Felkins?
Now's the time.
Yes, Your Honor. Your Honor, I'm here to express my sincere remorse for my irresponsible and dangerous actions. There is no excuse for what I did, and I take full responsibility for what I've done. I've had my ups and downs, and I've worked hard to erase my past mistakes. I know on paper it doesn't look good, and I worked hard all these years to become a better man and a father. I have coached my son's football team up until he was in middle school. I've been my daughter's wrestling coach for the past 4 years, never missing any game or a match. This year I hit rock bottom. I lost my wife and kids to divorce because of my drug addiction that I didn't believe I had. Spiraled out of control and lost my way. That night I was in jail, locked up, embarrassed at what I did, and the shame I had brought to my family. And what kind of role model am I? I have since completed a drug and alcohol program, and with the help of my counselor, I was able to overcome my addiction. I'm also attending a BIT program that has shown me a way to communicate my problems instead of overreacting, letting my emotions control my thoughts and actions. I want to apologize to the officer who I disrespected for not following his orders. I want to apologize to my family who has stood beside me and me bringing shame to them for this blatant disrespect. I want to apologize to the court and apologize to you, Your Honor, for having wasted time and resources. So I'm coming before you today, Your Honor, and ask for leniency and mercy for probation, as prison sentence would be devastating to my family and my job. I am the main income, and without me, Your Honor, we'll lose our home. And in these hard economic times, this takes both of us. My small family-owned business relies on me to bring in work and new clients. Without our business, we'll suffer. Without the income, it would put a huge financial burden on my parents. Your Honor, I hope you can see that I am able to change and not give up on me and throw away the key. I want to thank you for your time and understanding and consideration. Joshua Felkins.
Well, thank you, Mr. Felkins. Court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of fleeing or attempting to elude an officer, a severity level 9 non-drug person felony, in which the defendant has a criminal history score of B, thus placing him in grid box 9B. Court hereby sentences the defendant to the standard term of 14 months in the custody of the Secretary of Corrections in the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court has considered but declines to impose a fine in this particular case. Implicit in the court's announcement of its ruling is the court's rejection of the defense's request for a durational departure, the court believing that the standard term is appropriate given the facts and circumstances of this case. Court must also rule on the defense motion for a dispositional departure, where a request not to impose the presumptive prison sentence essentially Department of Corrections Penitentiary, has been made by the defense and argued and submitted by a written motion to the court. Court has considered this case. Court would make the first observation that it agrees with Mr. Sweeney. Every flee and elude, especially one where reckless driving or speeding are involved, to get away from the police is an inherently dangerous situation. It doesn't just put Mr. Felkins or a passenger in his vehicle at risk, but any other motorist that may be in the area, not to mention the law enforcement officers in pursuit. So each one of these is, in and of itself, a serious, serious crime in which punishment is called for. Mr. Felkins clearly recognizes this. He's to be given some credit for that. But I certainly understand Mr. Sweeney's position that each one of these need to be considered for harsh punishment just because of the nature of it and the public risk that's involved. With that said, the court does not see this necessarily as a case for imprisonment in a Department of Corrections penitentiary. Therefore, this court, for the reasons stated in the motion for dispositional departure submitted by the defense, will grant that motion for dispositional departure. This court will grant Joshua Felkins 12 months initially of reporting probation to be supervised by community corrections. Court finding that community corrections supervision is appropriate because this is a downward dispositional departure from a presumptive prison sentence. Conditions will include reporting to a community corrections officer as directed. Mr. Felkins must observe all laws, not have in his possession alcohol or illegal drugs. At his ISO's request and at his own expense, he shall submit to random breath, blood, and urinalysis testing, perform community service work pursuant to program requirements, gain and maintain employment successfully throughout his probationary term, notify his ISO within 48 hours of any change in employment status, residence, telephone number, or email address. He shall submit his DNA to the KBI data bank and be responsible for the $200 cost of the test. Abide by any curfew or travel restrictions associated with community corrections programming. Follow all standard conditions of probation. Not have in his possession firearms or dangerous weapons. And avoid disreputable characters and places. And make monthly payments on his obligations in a manner acceptable to the court. Those obligations will include a felony docket fee, felony probation fee, a community corrections fee. Is there any restitution here for the court to consider, Mr. Sweeney?
No, Your Honor.
We'll also assess a $100 bids application fee. How much are your fees in the representation of this client, Mr. Watts?
Your Honor, bids bills this at $720.
Mr. Felkins, it appears that you have the opportunity to become gainfully and stay gainfully employed with a good business. Mr. Watts' services have obviously been very valuable to you. I'm going to assess the entire $720 amount against you in this case to be repaid to the state. I'm not aware that there'd be any other applicable assessments. Mr. Felkins, despite the court's failure to follow the legislature's presumption here that someone with your criminal history and your severity of crime should go to prison, you need to be held accountable for what you did. And I think you fully recognize that. Therefore, this court will impose 60 days in the Butler County Jail as a condition of probation in this case. Court does note he has 1 day of jail time credit, so he has 59 more days to do. And I want that to start immediately, Mr. Felkins. You're not going to prison, but I believe an extended jail sentence is appropriate punishment for the dangerous situation that you created, and I think freely admit. Though the court is sometimes in similar cases not really receptive to work release privileges, this would appear to be an appropriate case for it. The court will grant work release privileges to this defendant. However, he needs to meet any program requirements at the Butler County Jail that have been established by the sheriff. In this case, I encourage it, Mr. Felkins. I think it would be good for you, your business, your family, everyone involved. But again, you have to qualify for work release privileges under the sheriff's rules because they administer the program. But there will be no court-ordered impediments to you starting work release right away. Court's already dealt with the issue of restitution and jail time credit. I won't go back over that. He just got 1 day that will be reflected by the journal entry, and that is to be credited against the 60 that the court has imposed here today. And someday in the future, Mr. Falcons, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any question about your right to someday seek expungement, you may address those to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, you could have the opportunity to appeal your conviction to an appellate court having jurisdiction. If you're unable to pay the cost of an appeal, you, the defendant, may request the court to appoint a lawyer to represent you on appeal and that you be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. All right, Ms. Ashton-Felter, I think I'm going to designate this case, since this jail time is issued as a condition of probation. His probation is going to start immediately, though obviously he's not going to have reporting requirements until he gets out. I want to start the clock running for his probation. I think he's a good candidate to complete within the year anyway. Furthermore, if he doesn't report to the jail when I tell him to, or he has major issues while on work release, I want this to be a violation of his probation conditions. So successful completion of his 60 days in jail, less the 1 day, he's got 59 more to do, is listed as a condition of probation in this case. It's an unusual order, Ms. Ashton-Felter, but I think it's appropriate under the circumstances. Mr. Falcons, normally, when you're at the Judicial Center, I order you into custody immediately. In this instance, you're in your attorney's office, and I allowed you to do that. So you're certainly not in trouble with the court over that. But I do need you to immediately report to the Butler County Jail, which is east of El Dorado. If you don't know where it is, I know Mr. Watts does, and he can give you directions. And you need to be reported into that facility by no later than 2:30 p.m. this afternoon. Do you have any questions about that, Mr. Falcons?
No, Your Honor.
Okay. Look, the court has imposed what you may see as a severe jail sentence. I think you're aware of what you were facing when you came in today was a much, much longer prison sentence. I think you have everything in place to be 100% successful on your community corrections and on any work release program that you may qualify for. So take full advantage of this opportunity, and then maybe, just maybe, you'll never have to appear before a judge again to face sentencing for the remainder of your life. Good luck with that for the rest of your life, Mr. Falcons. I hope you're truly successful.
Thank you, Your Honor.
Thank you.
All right. Okay. Mr. Watts, anything further we need to address?
No, sir. Thank you.
Or Mr. Sweeney?
No, Your Honor.